So we're going to have a look at the case of Stephanie Van Groll versus Kenneth R. Kratz. And this is the decision and order of none other than William Griesbach. That's Mike Griesbach's brother. And it's a very long decision. I must say I'm very impressed by what William Griesbach has written. It seems to me as if once public opinion has shifted one way or the other, then things do get done properly. It's just trying to shift this tanker from going in one direction to get it to shift to another direction. So anyway, here we go. This might, as with the press reports, this might take several parts to get through because it's a huge document. But anyway, I think it's worth looking at because it is so important. The case raises the question of whether the solicitation by a district attorney of a sexual relationship with the female victim in a domestic violence case he is prosecuting amounts to a violation of her right to equal protection of the laws within the meaning of the 14th Amendment of the United States Constitution. Plaintiff, whose initials are SV, filed this action for damages against defendant Kenneth R. Kratz, the former district attorney of Calumet County. Plaintiff alleges that Kratz violated her constitutional rights when he repeatedly sent text messages to her over a 3-day period following a meeting she had had with him to discuss the prosecution of her former live-in partner for attempting to strangle and suffocate her. In the course of his text messaging, Kratz solicited a sexual relationship with the plaintiff. Given the unusual nature of the case, at least as gleaned from the facts alleged in the complaint, the court invited the parties to address the threshold issue of whether the complaint stated a constitutional claim before undertaking full discovery. The parties agreed, but instead of simply filing a motion to dismiss, defendant filed a motion seeking dismissal pursuant to rule, whatever it is, and alternatively for summary judgment pursuant to another rule supported by a set of proposed findings of fact. Plaintiff responded to defendant's proposed findings and submitted additional proposed findings of fact supported by her own affidavit. Since a motion for summary judgment encompasses the question raised in the first rule, motion of whether the plaintiff has stated a claim in the first place, the motion will be treated as one seeking summary judgment. For the reasons that follow, the defendant's motion will be denied. Remember, the defendant is Kenneth R. Kratz. Summary judgment standard. A motion for summary judgment should be granted if the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. Where actual disputes do exist, the non-movement's version of events is accepted as true at this stage of the proceedings. The mere existence of some factual dispute does not defeat a summary judgment motion. However, there must be a genuine issue of material fact for the case to survive. Material means that the factual dispute must be outcome determinative under governing laws. Failure to support any essential element of a claim renders all other facts immaterial. A genuine issue of material fact requires specific and sufficient evidence that, if believed by a jury, would actually support a verdict in the non-movement's favour. Where the record taken as a whole could not lead a rational trier of fact to find for the non-moving party, there is no genuine issue for trial. So, undisputed facts and allegations. In this case, the basic facts appear, for the most part, undisputed. After years of living in an abusive relationship with, Shannon Konitzer, the father of her child, the plaintiff reported to police an incident where Shannon had beaten and strangled her. On August 12, 2009, he was charged in the Circuit Court for Calumet County with felony strangulation and suffocation under circumstances that constituted domestic abuse, as that term is defined in the Wisconsin statutes. Plaintiff had not reported past instances of his abuse to the police because she was reluctant to invite law enforcement authorities to intervene in what she considered a private family situation. She was also concerned that reporting Shannon to the police would only anger him and increase the risk of more serious attacks in the future if he was freed before trial or was not successfully prosecuted and sentenced to jail. Her hope in reporting his conduct to the police was that he would be punished for his violent and abusive behaviour and prevented from repeating it in the future. Defendant Kratz, who was then the district attorney of Calumet County, where the offence had occurred, met the plaintiff 3 times in October 2009 in connection with the case. In the first 2 meetings, the officer's victim witness coordinator was present. At the 3rd meeting, which occurred on October the 20th of 2009, Kratz met alone with the plaintiff in a conference room at his office. In the course of the 3rd meeting, plaintiff described her relationship with Shannon and his previous abuse. Plaintiff also explained her personal circumstances, telling Kratz she was not in another relationship at that time, that she was living with her mother, was struggling to make ends meet while caring for her child, and that she had extremely low self-esteem. Kratz confirmed at the meeting that he would be in charge of the prosecution, which plaintiff understood to mean that she would be relying upon him directly for assistance regarding her participation in the process as the victim of the crime and the complaining witness in the prosecution. She also understood that Kratz, as the prosecutor responsible for the case, would have substantial influence and control over whether Shannon would be released before trial, and, if so, the conditions under which he would be released. He would determine the conditions of any plea offer by the state or the evidence that would be offered at trial if a plea agreement was not reached, and would have a significant say over the sentence imposed if Shannon was convicted. In fact, Kratz asked Stephanie at the meeting if she would object to reducing the felony charge against Shannon to a misdemeanor. She stated she would object. Finally, she believed that Kratz and law enforcement in general would protect her identity and privacy as much as possible if she cooperated with the prosecution of Shannon, and that her contact information would be kept confidential and used only for law enforcement purposes. On October the 20th, 2009, shortly after their meeting, Kratz sent a text message to Stephanie, which states, "It was nice talking with you. Feel free to text me, in brackets, between 8 and 4, if you are bored. You have such potential. See ya, Ken," in brackets, "your favourite DA." This was the first in a series of 30 text messages that Kratz sent to Stephanie over the next 48 hours. She has submitted a transcript showing the date, time and content of Kratz's text messages to her, and a separate transcript of her replies. Now, Stephanie replied to 23 of Kratz's messages, although the transcript does not show the date and time of her replies. One can, for the most part, determine the messages to which she replied from the content of the message and the reply. It is clear from her replies that at no time did the plaintiff communicate to Kratz that she wanted him to stop sending such messages to her or object to their content. As she later explained, however, this was out of fear that Kratz would retaliate against her by the manner in which he handled the prosecution of Shannon or in some other way. In apparent response to Kratz's first text message set forth above, Stephanie said, "Don't worry about me. My motto is just keep going, and thanks for everything." Now, that appears to have replied shortly after Kratz sent his first message, because at 3:55, a few minutes later, he responded, "I'm not worried. Well, maybe just a little. I'm more curious what made me text you." Stephanie replied, "Because you're a nice person." She's a bit deluded there, but never mind. Kratz responded, "Okay, we'll go with that answer. Thanks for putting up with me so far. I wish you weren't one of this officer's clients. You'd be a cool person to know." And Stephanie apparently replied with thanks, and Kratz did not respond further that day. We'll do one more paragraph. As I say, we'll need to split it into various parts. At 10:48 the following morning, Kratz sent another message to Stephanie telling her he was feeling bored and inquiring if she was even up yet. She replied that she had a fever and hoped it was not the H1N1 flu that was in the news at the time. 20 odd minutes later, at 11:18, Kratz responded, "Oh no, I hope you feel better. Do you want me to bring you some chicken soup?" Stephanie replied, "Lol," an accepted text message abbreviation for laugh out loud, and continued, "No, I don't want anything to eat." Kratz responded, "How about a margarita that has some fruit juice in it?" Plaintiff replied, "Lol, too funny." Kratz texted back at 11:32, "Seriously, I hope you feel better soon. Please keep in touch. It's maybe not the wisest thing I can do, but you are awfully sweet. Just don't tell anyone." To which Stephanie replied, "I'm telling everyone, JK." And we get the explanation, an abbreviation for just kidding. Haha and thanks. We'll leave it there because that was the first part of the sort of flirtatious part by Ken. And we'll move on to, as I say, we'll go through the whole of this document by William Griesbach and look at exactly how he, as this judge, as I say, I'm quite impressed with his findings, his assessment of it. It shows that judges over there in Wisconsin, they can be good. One wonders, though, as I say, about the efforts of the sort of publicity. You know, once there's a public campaign and it starts to grow, then these people in Wisconsin, they do fear for their next election. Anyway, we'll catch you again soon. Bye for now.